You have questions, we have answers. This is Jane Muller.
This is Ken Muller. Welcome to our show, all about real estate with Ken and Jane. Well, Jane, back by popular demand, we're going to talk about landlord-tenant issues.
We get calls all the time.
A lot of questions. So we did a show within the last few months about it, but we didn't get nearly enough time to answer all the questions we have about it. So one of the questions we had is what should be included in a residential lease? So, I mean, if you work with a realtor, you have the New Jersey Association of Realtors lease that the realtors can fill in the blanks. Certainly, if you're not using a realtor, you can get, there's different
attorneys.
There's different attorneys can get involved and prepare the lease. It is probably a good idea to have an attorney. If you are going to do it yourself, I mean, you can do it yourself. It's not against the law. Obviously, you should have the names of the landlord, names of all the tenants that are should be specified in the lease. You should have the start date of the lease, the end date of the lease, the rent amount, the security deposit amount, repair clause on the required repairs, pets. You should address the pets terms, late payment fees. What happens if the rent is not paid within, if it's due the first of the month, what happens if the rent is late? What's the consequence? That has to be addressed in the lease. Smoking, utilities, who pays the utilities. These are all
landscaping.
Things. Yeah, landscaping. There's a whole
snow removal, if there's any. I mean, Ken, right? I know now the AI is very popular, and like ChatGPT become a phrase, right?
Mm-hmm.
A lot of people want to do themselves, but I would highly recommend the landlord do not do yourself, because whatever you can find online may not be associated with the state. If even they waste the state, they may not be updated. So right. I would highly recommend to hire professional, such like a real estate agent. They would help you with the process. Or if you want to do it yourself, which is 100% fine, but please have an attorney to read through the prepared lease. And this lease, right, can be reused, but just need a little bit updating. If you have the lawyer specialized in landlord-tenant attorney, and they can prepare the lease from time to time. If it's a tenant stay a few years, ask the lawyer to review it to update it. I mean, this money is worth to spend, because you don't want one day, God forbid, and you have an issue with the tenant when you go to the court and your lease was not up to the law or was not right well. So you want to prevent that. Why you have a lease in the first place? Mm-hmm. Because, why you have a lease? Because if everybody do what it's supposed to do, I mean, why don't you do the handshake? Because you want the legal documentation to protect you in case anything happen. Why not spend some, effort and time and money to make sure the instrument is updated and correct in the first place? So that's very important, because I had so many people said, oh, now if I buy a house, I don't need an attorney. Anything, I don't need an attorney. I just Google it. I just, do the ChatGPT, give me everything. I did have a client, my past client, and had some issue. It's nothing to do with the real estate, but they Google, they wrote something, sent to me. I said, first of all, I'm only a real estate agent. I'm your friend, but I'm not a legal attorney. I'm not an attorney. You should seek an attorney. But I got it from online. I said, read okay, but I don't know the law. You have to consult the legal professionals. So
right.
that's.
ChatGPT is great if you want to check something, supplement it, but it's not the be-all, end-all. It's not.
This is a legal document.
This is a legal document. And the purpose of a lease is really to outline the rights and responsibilities of the landlord and the tenant.
And the tenant.
How the tenant is required to upkeep the property, to return it, what happens if there's damages. There's so many provisions in the lease that have to be committed to writing, so that both parties know their obligations. Yeah, just what's the expectations. So
absolutely. It is going back to expectation versus agreement. We had show about that. It's a lot of time, right? Expectation It's not agreement.
And in New Jersey, while a lease can be oral, it is highly recommended to be in writing because there's so many times where people have agreements, but then what's said orally doesn't get it. There's a misinterpretation, and it doesn't. So if it's in writing, it should be in plain language, but it should be in writing. So it's pretty much as.
But it's verbal. First of all, how you prove you said it?
Right.
If only between two people, right? Yeah. One person say I did, the other one say no, you didn't.
Right.
And secondly, even we both talking. If we both agree, we had a discussion about that, maybe the understanding of the content could be very different.
Right.
So a lot of time people only thinking the way they believe they're thinking, right? So,
So that's why a lease should have things such as, the repair responsibility, who's responsible for repairs, and if the tenant's responsible, up to what price, who's responsible for the HVAC, doing routine maintenance, changing the filter. These are so many things that go into, upkeeping the house. Who's responsible for the grass? Who's responsible for the gutters? Who's responsible for the trimming the landscaping?
Yeah.
Because the tenant could say, well, the lease just said I cut the grass. They didn't say I have to do anything with the landscape.
We did have that issue. The landlords hire, thank God it wasn't us. So the landlord hire agent to rent the place out. And the agreement is the tenant is in charge of the cutting the grass, which is true, they did. But after 2-3 years, there was a luxury home. After 2-3 years, when they finish it, the lease, the landlord hired us to take over. And there was so much weed grow. At the end, it cost landlord $2,000-$3,000. Just had a maintenance people come in, just not improving it. I'm not talking about improving the landscaping. Just brought it back the way it's I would say minimum standard it should be. Not even improving, just minimum standard to get rid of weed, get rid of something, and just trim a little bit. That was just a minimum $2,000-$3,000. For that. So you have to really specify in the lease who's doing that, just like the weeding is very important too. There's so many
there's so many
details.
things. And that's why if you have a realtor, it's also the pre-move-in walkthrough, which is very important to document the existing condition via photos and being a written checklist of what the conditions are when the tenant is taking over the lease, and then have a final move-out walkthrough when the property is vacated, what the condition is.
Yes.
You have to determine if there's, and that's very important.
Yeah.
Those are two big
lot of details.
A lot of details. And, you can have a property management company. That's a service that can be farmed out. But, it depends on each individual's circumstances and their time commitment. But that's something usually if you have a realtor, at least at our team, we normally do that. We always do that as a pre-move-in walkthrough and a final move-out walkthrough. As a courtesy service and to the landlords and the tenants. Yeah.
Absolutely. It's very important. And to hire management company, you should ask what their responsibilities and the fees. So that's another day topic.
Yeah.
But today, just on the lease, it is the lease itself is the written document. It's the foundation. It's the base of everything. So you have to get that right.
Right. Now, here's a very popular question. Let's say you have a lease. It's a 1-year lease. The tenant is supposed to move out on March 31st, 2025. What happens if the tenant what happens if both the landlord and tenant do nothing? They forget that the lease expired and the tenant just overstays but continues to pay rent, and they get the rent beginning of April, May, June. So what happens in that case? If the lease ends, does that mean the tenant has to move out? Well, it doesn't. This is a very interesting question. In New Jersey, if the tenant at the end of the lease term, if the tenant gives notice that they want to vacate, they intend to vacate, that's fine. The tenant has a full right to, leave the lease, and then they go through the whole procedure of, vacating and getting the security deposit returned within 30 days. But the interesting part in New Jersey is if a tenant decides at the end of the lease term that they want to stay, and if the tenant is in good standing, which we're going to cover, later, then the tenant has the right to stay indefinitely unless with a few exceptions, and they become a month-to-month tenant. And as long as they continue to pay the rent on a monthly basis, they have indefinitely they can stay. And the landlord cannot hold up the piece of lease and say, wait a minute, tenant, you were supposed to be out March 31st, 2025. You have to get out. No, it does not work. That's a very misunderstood concept in New Jersey. The tenant has full rights to stay unless the landlord has just cause to ask the tenant to leave. That's a very
Furthermore on that, I have another variation of what you just talked about again.
Well-
and I had a client, they had a 1-year lease, right? And then the landlord forgot, because normally the 90 days before the lease end, the landlord must inform the tenant whether the intention going to renew or not renew. But based on you said, if the landlord said they're not going to renew, but the tenant still have a right to remaining in the house month by month basis, providing they are in good standing with their payment and the other term of the lease.
Right.
However, in this case, right, the landlord was so busy he forgot. I always tell the landlord, once you rent it out, you put it in your calendar 90 days before. You can tell them 100 days before, as long as before 90 days, you give a tenant notice, ask the tenant, would you like to extend the lease, right? But landlord forget, tenant didn't say anything. Like your example, March 31st, the tenant text landlord and say, we moved out today, and I cut the utilities.
And the tenant has the full right.
And the owner the landlord was so upset, called me up, said, they should give me a note. I said, no, they don't, because your lease ends on that day. So nobody contact each other. So that means the lease term stays.
Right. The tenant controls the shots. The tenant can pull the switch and say, well, the lease says the lease ends ended March 31st, 2025. Therefore, I vacated.
Yeah.
And, let's do your inspection, and you have 30 days to return my security deposit with interest. But if the tenant decides they don't want to vacate, they don't have to give any notice to the landlord and say, Mr. Landlord or Miss Landlord, I intend to stay. If they just stay, and by their actions of paying the rent on time, they become a month-to-month tenant.
That's right. In that case, they tax landlord about that was summer. That was happening summer.
And you get this question must come everybody, and there's so much misunderstanding about this, because on paper, everybody says, well, their lease ends on this date, so if I don't renew it, the landlord's perspective is, if I don't renew it, that means that they're gone.
They not.
But no, they're not necessarily.
That's how I think, Ken, that's the kind of number one questions we get from the landlord, because they want to sell the house. They said, my lease and such date, and after that no, they can't.
Right.
And again and again,
But we're going to cover that now. There's an exception to that. There's a just cause exception, and that's if this you got to be careful with this. We're going to cover. There's a lot of nuances to it, but it's called if the owner truly intends to self-occupy the premises, or if they're selling the property and then the contract, they have a buyer who says that the house must be delivered vacant because the buyer wants to self-occupy it, not re-rent it. That's where we're going to get into. That's a very tricky thing.
We had
there's been litigation on it, but you have to have the true intent to sell and self-occupy, or the true intent to sell to a buyer who truly wants to self-occupy it.
Absolutely.
And then there's a procedure. You have to give notice to the tenant, and then if they still don't, then you have to go. We're going to cover that. We're just going to go to break now, and we'll be right back after these messages. Okay, welcome back to our show. So we're talking about leases in which the tenant, becomes a month-to-month tenant after the rent lease term has, quote, expired. But as we explained in the beginning of the show, the tenant still has rights to stay there as long as they're in good standing. Now we're going to get into the exception if the owner intends to self-occupy the property, or if the owner has a contract for sale and there's a buyer that's in the contract must state that the property must be delivered vacant because the buyer intends to self-occupy it. Mm-hmm. Now, if those facts exist, then there's a procedure that the owner has to give the tenant a notice. Usually it's a 60-day notice to quit, notice to vacate, at least 60 days before the intended move-out date is. That's what, they have to give notice, and that's something, if they don't give sufficient notice or proper notice by in writing, by certified mail, the tenant can contest that they never received it. So,
once again, I highly recommend the listener there, right? Ask your attorney to handle it.
Yeah, this is not legal.
We've been through a lot of cases like this, right? And the landlord had to sell, and the tenant obviously don't want to move out. There's quite a few cases we experienced. I always advise the landlord, ask the attorney who dealing with the contract for sale, and they probably can serve the paperwork on your behalf. I always ask the my clients to get legal advice. Because
Yeah.
at the end of the day, if you did it yourself, you didn't did it right, and then you're going to waste more time. So
Right. If it wasn't served in the
Yeah.
right manner, there's different ways you have to
Yeah.
prove that the tenant received it. So
Yes.
there's a whole different ways, and we're not going to speak to the service methods. But if there's an error procedurally,
and also the day,
that'll
how many
throw-
days they
how
can
many days?
do. Yeah.
Right. This is all intended to be fair to the tenant. You need 60 days for them to have time.
But once again,
Yeah.
this is not legal advice. So this is just our experience with our files and transactions.
Yeah.
Seek legal advice.
Yeah. Now this is just a notice to the tenant. Now what could happen is the tenant could get the notice. They could just ignore it and just say, "Well, I don't really want to move out." Does that legally mean that the tenant, you can go ahead and after 60 days and say, I gave you 60-day notice, you didn't move out, so get the heck out, I'm going to change the locks? No. Then once you've given the notice to quit, notice to vacate, if the 60 days has elapsed, then you can file a complaint for possession. And then that would trigger basically a court hearing where the tenant and the landlord would go. They'd present the evidence. You'd have an evidentiary finding, and the landlord would present his or her case, and the tenant would present his or her case, and the judge would make a ruling based on the facts and see is the owner truly intend to possess it, or does the owner truly have a buyer that intends to possess it? So that's where it comes a factual thing, and the judge might decide. The tenant might say, "Well, Your Honor, I need more time. I haven't been able to find anything." The judge is not just going to throw the tenant out on the streets just because.
We had an experience with something like that, right? There was, the court hearing 60 days later, and one case was the interest rate change. Because went up, right, a few years ago. The lockup, the rate is maximum 60 days. So at the end, we served them 6 days, and then there was have the court hearing. So the interest rate went up. So and then the buyer asking seller to give compensation. And but that time, that was 2-3 years ago. The market is still on the rise, so the seller refused. But at the end, the buyer waited because, the market went up. If we cancel and later on, probably the seller will get more money anyway. So the buyer okay with it. And there was another time, which has happened. The contract was the buyer cannot wait. It was like you said, Ken, they need more time. They need more time. The court was give the tenant more time after the 60 days initial, and the buyer backed out. So after that, the owner has to work with the buyer because you can't enforce that because you don't
have a contract.
Contract was canceled. So at the end, we wait almost another 7 months.
And then you have to reserve the tenant. And then the landlord probably said, well, in that case, I want the tenant to stay anyway, because if I have no buyer, then
they really didn't want them to stay because they're retiring. They really need the money to buy.
But they have no buyer, though.
Yeah,
so.
but they can't. So that's why at the end it was 6-7 months later until the tenant found them, because then in that time we'll have to take the home off the market, because I said to the seller, there's no point put on the market because we just waste one buyer family time and money to do this. So next time we just have to make sure they moved out first. 6-7 months later, finally they moved out. And so that's a lot of. The reason I share this is just share the experience so you know what possible issue may come up. Just give you a heads up that's in two case, one stayed, but the interest rate went up, and then the buyer wanted compensation. And the second one, truly, they couldn't wait any longer, just like nobody know when, right? So at the end, the buyer canceled. So after the buyer canceled, we'll have to drop the case because we have no case.
No case, right.
So, and then we stored from the market because I said there's no point. You have another buyer, we end up with a square one, right? So we go through the same process.
The judge could throw out the case if the judge feels that the proper notice wasn't served, the required 60-day notice, if there was something that was improper about that, or if the judge feels that the owner is lying.
Yeah.
If the facts based on the based on the evidence, the judge says that doesn't genuinely believe that the landlord is going to self-occupy it, or they could decide to give him more time. If the tenant makes the plea, it all depends on the facts. The tenant could say, "Your Honor, my kids are in the school system. It's April now. I need them to finish the school year out, which ends in May, the end of May.
June.
So give me June, and then it would be a hardship. The judge will weigh all that. So it's nothing. It's no written rule. The judge will take the totality of the circumstances and just make a decision that's in the best interest of both parties. That's try to be reasonable.
Yeah.
So, and I should say something. Another question we had: what if the owner just changes their mind after? Let's say the hearing, the judge rules in favor of the landlord eventually and says, "Okay, Ms. Tenant, you have to be out. I'm going to give you till June to get out, and otherwise it'll be a warrant for the removal issued by the court, and then they can the special officer." What if they find out the landlord does not occupy the property? Let's use that scenario where the landlord intends to occupy it. That's a big issue. That's a misrepresentation, and the landlord could be liable for a major lawsuit for damages, attorney fees, and costs from the tenant side. So that's that's committing a fraud. You're misrepresenting.
You know what?
So that's something you have to be very. And if your landlord, if it's the owner, if the owner is the one that's going to self-occupy it, the law has it. From what I understand, you have to do it for at least 6 months. You can't just go in there for a month.
Even 6 months, can. A lot of time, right? I mean, I have an owner call me, said, how about I just tell them I move back, I'll move back for a little bit and I move out. I said,
but no, that's because
I immediately I said, your intention is wrong. So I wouldn't want to have anything, part of it. That means you misrepresent. That's unless you truly move in. I mean, obviously in 6 months, 2 years, you may get a job transfer. That's totally understandable. Nobody can control that, right? But if you plan it, you knew you just want to use that, be careful. Because you misrepresent, you get sued. Yeah. So I would tell them, I mean, first of all, I'm not going to represent you because this is not right. Fraud, you're a fraud. It's like, that's just very serious.
And here's another thing that's equally serious. Let's say the buyer has the intent of basically wanting to re-rent it, but wants the current tenant out because maybe the current tenant is paying less than what the current market rent is. If the buyer does the same thing, then they're equally liable for misrepresentation.
Ken.
So sometimes the buyer might say, well, that tenant's been there a long time, but gee, I can get it $300 more a month if I get rid of that tenant. So I'm going to say I'm going to self-occupy it, but I have no intention. That's committing equally.
As a leasing agent, right? If we had a case, we had a few cases have to go to court. I did my own diligence to protect all parties. Okay, when that happened, when we prepared to serve the tenant, I always ask the buyer agent put in writing, confirm the buyer is gonna self-occupy.
And then you could also verify
and the lawyer,
by the loan officer
exactly. That's what I'm gonna say. Yeah. The lawyer will have in writing. The agent had writing. Lawyer had writing. I always make sure call the loan officer and confirm it. And I Google where the buyer live now. Right. I said, well, if they live in a bigger house, that's what they're doing. Are they going to keep it? Are they going to be on the market? Are they going to plan to sell? I always do my own diligence. I mean, at the end of the day, if the buyer flat out lied, it's nothing I can do. But at least I get reasonable explanation, at least pass the smell test here, right? Give me a good explanation, and I can make sure put on a file. Mm-hmm. So to protect the seller. So, to protect everybody here, right? I mean, lying is never be, long time ago, I had a client and saying, that was the bank possessed house, so the no investors, right? And then you have to be self-occupied. Oh, yeah. They said, well, can I just buy my kid's name and empty for 6 months right now? I said, absolutely not. That's a fraud. Yeah. That's a fraud. It's flat out fraud. Do not do anything illegal. So they will catch up with you. And you wish, you never did it. So just do the right thing. And once again, in this case, can confirm with the buyer agent through agent and the buyer attorney and then buyer loan officer. Have a good explanation why. Obviously, if they rent it, you don't, they buy a house for them to live, right? If the person own a property and why they need this one. So you need an explanation to protect your client.
Yeah, do
I mean,
your
the
due
judge
diligence.
probably going to ask that anyway
Yeah,
during the
it'll
court.
be a fact finding. That's
Yeah,
a lot of things
yeah.
depend on the facts, right?
Yes, that's right.
Yeah, the judge is gonna do what's fair and
Yeah.
what's
But why don't you just do the groundwork at the beginning so
yeah.
you cover all the base?
Just like you do the groundwork if you're a list agent
Yeah.
and get an offer, you do the groundwork on the buyer's financial
That's right.
qualifications. What do they
Yeah.
own? Do they rent? Are they a 1099? Are they W-2?
Yeah.
How long have they been at the job? Whatever information you can gather from the loan officer.
Yeah.
And to get
And
to gauge their
from
job.
LinkedIn too.
Yeah, there's so
From
much,
the
right.
social media.
Yeah, there's so much with social
Yeah.
media now you can do. Absolutely.
Yeah,
Yep,
that's right.
Good. So so that's very important. This whole thing about self-occupy, and of course, other grounds. If the tenant is not in good standing at the time that the lease
That's
ends,
different.
then you can also move. And what would be examples of not in good standing if they have violating like excessive noise, a lot of partying, a lot of damage to the property, illegal activity going on. Then you'd have to send them a notice to quit. And give them, an opportunity to correct the lease violation, and then it would depend upon, and that gets into we're not going to cover, that's beyond the scope of this show, but then how much time do you need for that notice before you can
seek legal advice?
You would need legal advice, so it all depend on the facts. If they'd had a party one time on a Friday night and a Saturday night,
Birthday.
and then you gave them a notice and said, hey, the neighbors, you're in a condominium, the neighbors complained there was excess noise after 10 p.m. You're in violation of the lease for disturbing the peace of the neighbors. You're creating a nuisance. Please stop this activity. Failure to do so will constitute a violation and will result in a action being taken to have you vacate the property. And if they continue that for maybe 2 weekends or can keep continuing it, disregarding it, then But again, you have to seek. Everything is fact specific. Depends on the timing, and there's no one shoe size fits all.
Yes, that's correct.
It really depends. Yeah.
Yes.
Yeah. So let's talk also, I know we covered this the last show, but also security deposits. I think it's important to reiterate. Security deposits for New Jersey residential lease are limited to 1.5 times the rent.
Maximum
1.5 times the monthly rent. When they're collected, usually at the time the lease is signed, within 30 days of the landlord receiving the security deposit, they must provide the tenant with written notice of the financial institute where the security deposit has been deposited.
Yep.
That is it has to be in an interest-bearing account.
Yep.
And it's supposed to be by certified mail. That's according to the law. But I mean, now I think you want to confirm the tenant receives it. Now I'm sure a lot of people do it by email or through the agents, but they still have the certified mail thing. That's a very important thing, because if you do not give the proper notice for the security deposit, then there's something in the law that allows the tenant to use the security deposit for rent if they've failed to be served with proper notice. There's a little loophole in that.
Yeah.
And then you have to return it once the tenant vacates at the end of the lease. You have to return it within 30 days, the security deposit plus interest. And then if there are truly damages, which we're not getting into, beyond ordinary wear and tear, they have to be itemized and deducted. But then that's a whole other.
They have to be mutually agreed.
Mutually agreed. We could do a whole year show on damages.
Yeah,
There's been many cases on that, so it's not an easy fit. Again, it's a good idea to do a walkthrough before you move in and after they move out. Video are always good. That's something that agents do. We always do to document the best you can document in writing. If you do a pre-move-in walkthrough sheet, you write down that the tenant might want to say, hey, the carpet in the family room has a black blotch on it. I'm letting you know that, so I'm not responsible for it.
That's right.
Whatever you can document, the extent, the better.
Yes.
Right. So we are just about out of time. Oh, one last thing on the security deposit. If it's wrongfully withheld for something, then the landlord is liable for 2 times the damages of the amount wrongfully withheld.
Yes.
So keep that in mind. All right. We're out of time. We hope you guys enjoyed the show. Have a great rest of your weekend. We'll see you next week.
Thank you.